everybody.
Whoa.
I've got a couple more in the waiting room, we're just going to let in. Okay, so I'm just going to mute everybody, if I can work out how to do that. Mute. Okay, so thank you all for attending. We did have a few more, but they've dropped out at the last minute, and we may get more people joining as we go on. But if they're late, then that's their problem, not mine, isn't it? So we're going to crack on with the presentation and the webinar. And as it says in the details of it, it's partly going to be a Q&A session of the most frequently asked questions that we have coming into our office, but then also I've been sort of doing a little bit of an overview of different sort of HR topics as well that I think maybe will help you all. And this week we're going to go over investigations, which are critical within a business. So let's get cracking. Let me share my screen with you all. Okay, so for those of you who don't know us, we are Bhayani HR Employment Law. My name's Catherine. I'm the Senior HR Advisor within the firm. And what do? We do anything really that's employment law related or HR related. So we can help you with performance management, contracts, grievances, redundancies, discrimination, employment tribunals, pretty much anything you can think of that's HR and employment law, we can help you with it. And we also, as part of our offering, we have what's called a watertight package, which is a retainer that you can take on where you can have ongoing support. And we also can help you with your health and safety needs if required. So if you do need any help with anything at all, just give us a bell. So, like I said, we're going to go over a couple of different HR topics, and one in this one, which is investigations. And then we're going to move on to questions and answers that we have coming into our office on a regular basis. So when you're doing an investigation, it can be done for a number of reasons. It could be done because there is an ongoing issue where you think it might end in a disciplinary. It can be done as part of a grievance procedure. And in some circumstances, it can also be done as part of performance management. It's more rare for it to be done in that guise, but it can still happen. So what is the role of an investigator when we're looking at investigating whatever issue it may be? So it's to be fair and objective so that the essential facts of the matter can be established and a conclusion on what did or did not happen can be reached. And ordinarily it would not be the investigator that decides on that conclusion, they simply gather fact. In a disciplinary forum, for instance, the investigation would be done and then that would be passed to a disciplinary officer who would then make a decision as to whether or not there was a case to be answered at disciplinary. And an investigator should look for evidence that supports the allegations, but importantly, also evidence that contradicts it. So it needs to be fair and you need to look at it from both sides. And in potential disciplinary matters, it's not an investigator's role to prove the guilt of any party, but to investigate if there is a case to answer. Okay, so your first port of call really should be drafting an investigation plan. So it will provide you with a structured approach to follow, and it's quite important that you do that. It can help you focus on what facts need to be established, what evidence needs to be collected, and it can also help you to complete the investigation within a set time scale. However, it's important that you should be prepared to modify the investigation plan, and because when you're doing an investigation, sometimes information can come to you that you had no idea was in existence or that you're completely unaware of, and it might mean that you need to go off on a different course. And so whilst it's good to have that investigation plan, it's also very important to remember that sometimes you might need to bend and flex that plan to suit what information you gather. First thing you should do is check all your policies and procedures. You should collect copies of any procedures that may be relevant to the matter. Now, that's not just procedures that you are going to be using to guide you in terms of your investigation, because you might have got some policies that guide how an investigation needs to be done, but also there could be that there are policies and procedures in place that are pertinent to the investigation. So for instance, if you're looking at somebody who has not been following the sickness absence procedure, then the sickness absence policy would form part of your investigation pack, because that is the policy that they have breached. Okay. And even if you're already aware of the policies, we always say that you should reread them so that you can refresh your knowledge and ensure that the correct procedures are followed wherever required. Then you need to go on to identify possible sources of evidence. So these can take many forms. There's no exhaustive list that an investigator can rely on to know, because every situation is different, every business is different, every employee is different. So I can't give you a definitive list of these are the possible sources of evidence that you can look to. It's about sitting down, thinking about the issue and thinking about what you can gather and where you can gather it from. An investigator should remember that you not only have to conduct a reasonable, have to conduct a reasonable investigation. You don't have to investigate every minute detail of the matter. You only need to investigate what's reasonably likely to be important and relevant. So deciding in what order the evidence should be collected. Again, there's no definitive rule on this, and it really is very case specific. I tend to prefer to gather all of my evidence first and then to do investigation meetings with the staff in question, whether it be one or many, just so that you've already got your evidence there. And that's my preference generally, but that's not to say that you can't ask questions and do an interview first, an investigation meeting first, and then go on to investigate. And it really is quite case specific again. Where the matter's straightforward, you should hold some or all of the investigation meetings at an early stage of the investigation. And in particular, if a person has made a complaint or raised a grievance, you should interview them first to ensure that you fully understand the matter. So if the reason for the investigation is somebody complaining about somebody else or about a situation that's occurred, that should definitely be your first port of call, to interview them so you can get as much detail from them about what their complaint is, for you then to be able to investigate. But if it's kind of just a situation that's come to light, for instance, I don't know, you're missing money and you believe that somebody might have taken it out of a till, something like that, then I would probably gather all of that evidence first of all, your till reports, any CCTV evidence, things like that, and then go on to speak to the person involved. Also, what you need to remember is it might be that there's a suspendable issue going on. If it is theft or violence or something like that, and that can often guide you, because if it's something very serious like that, then I would be saying have the investigation meeting with the person in question first of all. And if it feels like the thing that has happened indeed, then you might want to look at suspending at the point of investigation meeting. So when to interview an employee under investigation, like I've just said, there's no definitive rule on this. You should consider interviewing the employee or employees under investigation at an early stage, because it can establish what the facts are, and it can allow you to focus the rest of the investigation on the areas. Also, if they admit the allegations, that's important. If they admit the allegations against them, then it might remove the need to investigate further. However, you might still want an explanation of why the incident occurred, because it might be that there's some mitigating factors there. Inviting relevant parties to an investigation meeting. So in some situations, you may want to give an employee advance written notice of their investigation meeting. It's important to remember you don't have to. It's not like it's a disciplinary or a grievance hearing or a sickness absence hearing where the person is afforded the right to notice of the meeting. An investigation meeting, you can just turn up and say, we're having a meeting now, and just spring it on them like that. And in actual fact, it's my preference to do that quite a lot in most of the investigations that I do, simply because you don't give them the opportunity to kind of come up with their arguments as to why they have or have not done whatever they're being investigated for. What I would say though is, if it is just somebody who is a witness to it, that you're wanting to gather information regarding the actual incident, then you probably would want to give them notice on it. If you are going to give notice, however, the invitation should include the date, time and place of the meeting, obviously, the name of the investigator and what their role is, the reason for the meeting, an explanation that the meeting is only to establish facts and it's not a disciplinary, a request to keep the reason for the meeting and any discussions confidential, and whether there is a right to be accompanied at the meeting or not. You should also probably put in there that if they don't, if they unreasonably refuse or fail to attend or don't cooperate with the investigation meetings, then that in itself can be a disciplinary issue, because they have an obligation to cooperate with you. Allowing an interviewee to be accompanied. So an investigation meeting, there's no automatic right to be accompanied. So there are some meetings where your employees have the statutory right to be accompanied. This is not one of them. So if one of your employees starts kicking off and saying that they've got the right to be there, to be accompanied, then that is not the case, unless it says in your policies that they are allowed to be accompanied and those policies are contractual, which goes back to my point earlier where you should always look at your own policies first of all so that you don't make any slip-ups. There are some situations where you may want to consider allowing it though. They are limited, the situations that we would recommend it, but there are some. So for instance, if English is not their first language, a companion can help facilitate the discussion. Having someone there can make an interviewee feel more comfortable, and sometimes they're more willing to talk openly about the matter. That's especially if it's something that's a little bit more sensitive in nature. They may be able to help an investigator manage the process more effectively by explaining steps being taken to an interviewee. And it can increase the confidence that the staff have in a credible process. So they'll look at that as being reasonable. There are some other situations where you might want it. So for instance, if somebody's got a disability where they need help, then you probably would want to allow somebody there. If somebody's under the age of 18, if you're employing people under 18, then it is also a good idea to have it in there. Or sometimes if people have got mental health issues, then it helps to be accompanied. And we would probably be actively recommending you to allow that because it just shows that you've acted in a more reasonable manner. What notes should be taken? One of the biggest issues that we see, to be honest, when we're looking at disciplinaries and whether they've been handled well or not, is the notes. And this is a real big ache. We often get notes that aren't sort of comprehensive enough, I think would be fair to say. So notes taken at the meeting will usually become an interviewee's witness statement. And so they should be comprehensive, and they should record the date and place of the interview, names of all of the people present, an accurate record of the interview. Now, it doesn't necessarily need to be word for word, but it does need to be an accurate record. Any refusal to answer a question should be noted, so it shouldn't just be left blank. You should literally write refuses to answer. The start and finish times and details of any adjournments. And the notes should be written without gaps, because people do sometimes accuse you of filling in gaps after the meeting's been held. I've had that myself. I very early on in my career did an investigation, and I didn't get the employee to sign it at the end of the investigation meeting, and this guy point blank said that the investigation meeting hadn't even happened. He was like, it just didn't happen, it didn't occur. Luckily we'd got CCTV to prove that it had, but he was adamant that I'd never met with him. So after that, every investigation meeting, every meeting I have really, once I've finished sort of making the notes, tidying up the notes, in the same meeting, I will give them the opportunity to have some time to sit and read through them, and I ask them to sign the bottom of every single page so that they can't say that it's been amended, or they can't say that it just never happened. And like I said, they don't need to record every word that's said, but they should accurately capture the key points of any discussion. When you're thinking about disciplinaries and whether they're fair or whether a dismissal that potentially comes on the back of a disciplinary is either fair or unfair, you look at the whole picture, which includes the investigation. And in actual fact, the investigation is almost more critical than the disciplinary itself. And one of the biggest things that we see when we think that something would be considered to be unfair is that the investigation has not been done efficiently and effectively. There's not enough information in it. And one of the biggest areas of that is notes from disciplinary meetings. So it's really, really, really key and critical that you get notes taken properly. And going back to that as well, what I would say is in an investigation meeting, you don't have to have a note taker if you don't want to, but I always recommend that you do, because from my own personal experience, it's really difficult to ask questions, listen to answers, write it all down and be forming your next question as well. Because you can have a list of questions that you think you're going to be asking, but obviously that they can be amended as you go because you don't know what the other person is going to say. So you can have a list of things that you think you're going to ask, but depending on their response depends on what you do actually ask next. And so that's really difficult to do whilst also taking notes. These days you can also record, especially because we're doing a lot of it like this, you know, remotely. But what I would say is ask them for permission to record. You need their consent. And if they say no, do not record it. If they say yes, then start the recording after you've asked them. And you can then, on the actual video itself, you can ask them to just confirm again that they're happy for it to be recorded. But I would also say if you do record, take notes as well, because technology doesn't always work in your favour. And so if something happens to that recording, it means that you've got the backup of your notes. So in an investigation meeting, the process is they're often difficult and emotional. If it's somebody who's raised a complaint, then they are sometimes emotional depending on what that complaint is. And also you come across a lot of anger as well, an emotion from the person who is under investigation, especially if you've sprung it on them because they're unaware of it being an issue. So you need to go in there ready for a little bit of emotion. You'll reduce unnecessary stress by pre-planning your questions. Like I said, you do need to be aware that those questions might have to bend and flex depending on the answers that you're given, but you should have your questions planned because it reduces the stress both on you and them if you've got, you know, if you've got it in mind what you're going to be asking, and it helps to keep the interview on the right track. Often as well, people can go off on tangents and start bringing other situations in. So if you've at the very least got the bullet points of the things that you want to cover, it means that you can make sure that you cover everything that you need to. And you should really only plan to interview each employee once, but it may be that as further facts are established, as more information is gathered, you may need to just revisit an employee to do a further investigation meeting, which is fine. However, we tend to say if you can keep it to one, it's better because it just expedites the whole process. And this is what we often get, people saying that they're either not attending an investigation or they just don't turn up or they call in sick for an investigation meeting because they're avoiding it. And it is really, really, really common, whether it's an investigation meeting or, well, any kind of meeting really, where people are worried for their job, then you tend to find that you get pushback. So if an employee refuses to attend an investigation meeting, you should try and find out why and see if there is a way to resolve the issue. It may be that they're unable to attend for legitimate reasons, such as illness, and you can rearrange the meeting or ask the employee to give a witness statement instead. Where an investigator doesn't believe a legitimate reason is being given, they could remind the employee that failure to attend may be viewed as refusing to obey a reasonable request and result in disciplinary action. And I think another thing that's important to remember is a lot of employees believe that if they're off sick, that you're not allowed to have these meetings, you're not allowed to do a disciplinary, that they're kind of protected. And that isn't the case at all. We would say that you need to show a little bit more caution if somebody's called in sick, especially depending upon what they have called in sick for. But it doesn't mean that these things can't happen. So just being sick doesn't mean that you just need to wait for them to come back before you can carry on with it. Okay, so that was a bit of a whistle-stop tour of investigations. Obviously, there's a lot more to it. I was just really wanting to give you a bit of an overview. One thing I did forget to say at the start is there is a chat function, which you've probably got on your screen. And if you have got any questions at all as we go through this, then feel free to pop them in that chat there. And then at the end, we will, my colleague Phoebe will collate the questions and we'll hopefully be able to answer them for you. So any questions you have, make sure you pop them in the chat and Phoebe will be able to pick them up for you at the end. So moving on to our frequently asked questions. So these are things that have been coming into our office frequently, repeatedly, and so we thought that if a lot of our clients are asking them, then there's a fair chance that you all might be asking them too. So the first one is an employee is saying I have a legal obligation to keep them on furlough and it's discrimination if I don't. So for it to be discrimination, first of all, they need to hold a protected characteristic. So they'd need to, it either would need to be on the back of a disability, which potentially would be clinically extremely vulnerable people, or to do with their sex, if it's a mother who can't look after whose kids are not in school for whatever reason. So it's not just automatically discriminatory, they need to hold a protected characteristic. If it is to do with an illness, a disability, it needs to fit into the legal definition. That legal definition is that it needs to be long-standing or going to be long-standing, and it needs to have a substantial detrimental impact upon their day-to-day life. There's no black and white when it comes to a lot of disabilities as to whether they are or they are not. There are some that are automatically. So for instance, cancer, that is automatically a disability, but there are some that have got that many, varying shades of grey, things like mental health issues, that it's not a given that it is a disability. And to be honest with you, the only times that you would get a definitive answer on things like that is in an employment tribunal, where the judge looks at all of the evidence available to them regarding the illness, and they make a determination of that. We can give you a good guide, but we can never say definitively. But even if it is a disability, there's no obligation to keep them on furlough as a reasonable adjustment. And if it's not a disability, then it's very low risk. So if somebody is saying that they really want to be left on furlough because they're not very well, then you should be removing them from furlough and placing them on sick. And then they would need to follow the usual sickness absence reporting procedures in terms of your fit notes and everything, whatever's held within your sickness absence policy. When using flexible furlough and an employee's wages increase due to minimum wage, what do I pay them on furlough days? So when you're flexibly furloughed, your hours are split into two. You've got hours where you are on furlough and hours where you are working. So the furlough hours is based on historic payments. So any increases to do with national minimum wage, or even if you've just given them a pay rise or whatever, will not affect your furlough payments because they're done on historic payments. And it's very clear on the government guidance about that. But any hours on furlough would be paid at that rate. Any hours working should be in line with either the new minimum wage amounts, or if you've given them just a random pay rise, then within that. So they will be two different figures. And like I said, it's very clear on government guidance about that. So you can always signpost your employees to the government website. How much notice do I have to give my staff to bring them back to work after furlough? A lot of staff are pushing back and saying, well, I need at least a week because I've got plans, etc., etc. So first of all, you need to check the furlough agreement that was in place. Often the furlough agreements that we sent out, if you used one of ours, or if you got them from elsewhere, will state in them what the notice period is. So first thing you need to do is just check in those agreements to make sure that you are adhering to whatever you've agreed to in those. However, within furlough guidance, they should be available to work immediately. That's one of the key points of furlough. They're kind of like on call. It's not that they're on holiday. So they should always be available to work when they would ordinarily be working. There's no specified timescale in terms of the government guidance. So you could inform them today that they're back tomorrow, and there's not much they can do about that. We are, however, suggesting that you give them as much notice as you can. I know sometimes that might be difficult depending on your industry, but the more notice you give, the more reasonable it is and the less likely you are to have them push back, because whilst we know that they should be on call, let's be honest, people are going to be making plans when they're on furlough. Do I need to update my risk assessment when government guidance changes? So you should update them anytime that there's an update, especially if you're in one of the industries that's just reopened today. You should have done a risk assessment for bringing people inside. And to make sure that your premises is COVID secure. And we say that anytime you do update them, you should share them with the staff. The staff have a right to see them, and we recommend that you make a point of sending them to the staff, because it is good practice and it shows that you're thinking about it. It reassures your staff. And Jason, I don't know if you've got anything that you might want to say about this.
Yeah, thanks, Kat. Yeah, I think it's important there that, as you've already mentioned, to share it with the staff, because there's a lot of clients or potential clients that I speak to who have done a COVID risk assessment, but they've not shared that information, but also general risk assessments as well. So it doesn't have to be your COVID risk assessment, but your general risk assessment. Share that information with staff. You know, there's a lot of companies out there that do the risk assessments. Equally, there are some that don't do them, which is a little bit of a worry. But, you know, as and when you do have a risk assessment and you do change it. So, for example, with, you know, COVID related, for example, you know, you might have a vaccine policy that you might want to put in there, depending upon sector. So if you're in the care sector, you know, there's obviously rules around sort of vaccinations and alike. And then some policy around sort of reporting of symptoms, which hopefully is going to, you know, negate a little bit now as most people are getting sort of vaccines. But, you know, things like the reporting of symptoms with health and safety, it's like anything in life. If it's not written down, it doesn't exist. So it's always better to have it written down and to share it with your staff as well. Just one thing I would say about general health and safety is, you know, a lot of companies that I see have a written policy statement, so a health and safety written policy statement, which kind of sort of says, you know, this is what we do and this is when we do it. But actually, when you look at the health and safety policies and procedures that they do or don't carry out, it kind of doesn't marry up. So if you've got, like some companies have, a health and safety manual that's on a shelf somewhere and you have to take it off and blow the dust off it, because sometimes it's not been sort of used in the way it should, have a read through. My advice would be have a read through that health and safety written statement policy, and just check what it states in terms of what should be done and when it should be done, and make sure what you're doing with your health and safety marries what your policy written statement is telling you to do. That's a biggie where certainly there's a lot of gaps need plugging with some businesses that I go and see. And just one final thing on that, just make sure you do it, because the health and safety executives are on the lookout and they are cold calling businesses. They're dropping in businesses unannounced. And that's one of the things they're going to have a look at. Show me your health and safety written policy statement, and then show me, you know, what procedures you put in place relating to that. If they don't marry, then you've got a bit of an issue. So if you need some help on that, then you know where we are, give us a call.
Yeah, and I don't know if people are aware, but if the health and safety executive come in and if there's work that needs doing in your business from a health and safety point of view, they charge you for it. So by token of them cold calling, as Jason put it, and coming in, if there's anything that needs rectifying, they charge you, and it's something ridiculous. Like, I think it's about £195 an hour or something like that. So from a cost point of view, it's worth having all of your stuff up to date and tipped up. So what if an employee alleges that they have caught COVID at work? So this isn't exactly within our sphere of expertise, because if somebody is alleging that, then that would be a personal injury claim. But we can give you a little bit of an overview of it. It's very difficult to prove from the employee point of view, as COVID is everywhere. It's not isolated to your workplace. It's everywhere. So they'd have to really go some to prove that they'd caught it within your business. But you can take steps to protect yourself, which is basically completing all of the necessary risk assessments and ensuring that all of those measures are in place and carried out consistently. So it's not good enough to just have the risk assessment and say, this is what we're going to do. You need to make sure that you are actually doing that as well, and that your employees are actually doing it. And we are getting a lot of questions around employees sort of refusing to do it, whether it's because they don't believe in COVID or whatever. They're just refusing to follow the measures that you've put in place. So what we would say is, first of all, look to educate them. So sit them down, tell them what measures are in place, why they're important, and what your expectations are. But if these people still sort of fail to follow your instructions in terms of the measures that are in place, then that would become a disciplinary issue. And we would say you should actively be taking control of that, just to protect yourself further down the line. And what do I do if my employees want to carry on working from home? So this is a big one, where employees have obviously got used to working from home and they enjoy working from home. I personally am not one of them. I hate it. I can't wait to get back into the office full time. But a lot of people like it for whatever reason. You know, it's improved their work-life balance. They feel that they can slack off a little bit easier when they're at home. The money saving element of it, because they've not got the commute and the parking, or, you know, they've just got a new dog and they want to, you know, stay at home with a new dog, and you laugh, but that's genuinely one that we got. So what I would say is there's no obligation to allow home working carrying on. Some businesses have actually found that it really, really works well for them. And not only are the staff being more productive, but in actual fact, the cost to the business has been reduced because you don't need to necessarily have the premises that you had before. So, you know, it's worth thinking about because it might actually be a benefit to you as well. However, there is no obligation to allow it. You may find that one of your staff puts in what's called a flexible working request. So if they do put in a flexible working request, then there's a statutory process that you need to follow, which involves a meeting. And then if you are going to decline it, you need to use one of the 8 business reasons. I can't tell you those off the top of my head because I can never remember them all, but there are 8 reasons that are set out, and your decline needs to fit into one of those reasons. You can't just say no without giving justification for it. So what we're recommending is, before people start putting in your flexible working requests, because a flexible working request, if accepted, actually becomes a contractual change, and then you can't very easily go back to sort of working in the office again. So, but if you have a home working policy in place that people can apply to work from home via, then what that does is it means that they probably won't then put in the flexible working request. And unlike a flexible working request, just having a policy in your business, as long as it states that it's non-contractual, you can then change it. So it's much better to do it through a home working policy that's non-contractual, because if something changes in 6 months, you know, if it's not working out for you anymore, then you can just change back, and it's not like it's set in stone like with a flexible working request. And we have got home working policies, so if anybody needs one, feel free to get in touch. And can my employees, can I pay, my employees' holiday entitlement in a lump sum? So short answer is no. The only time that you can pay the cash equivalent or in lieu of holidays is on termination of employment, whether that's through a resignation or whether you've dismissed. It absolutely is the only time that you should ever pay it. So on the face of it, it does sound like a win-win. The employee gets extra money and you don't have to arrange the annual leave, the cover while they're on their annual leave. However, the statutory provision, which is in the Working Time Directive, was designed to give employees time away from the work environment. And so there are sound health and wellbeing reasons for them to have that time. So by paying them, they're not taking the time. It's not about the money, it's about the time. And so for those reasons, you're actually not allowed to contract out at the minimum holiday entitlement by paying them instead. And it is actually unlawful to pay them in any other circumstance than on termination of employment. Except there are some situations where if they've got contractual holiday that's over and above what the statutory minimum entitlement is, in some circumstances you can pay for those, but certainly not the statutory minimum. And if you've got employees asking for it, then you need to say no. And technically, if they don't use their holiday entitlement, they lose it. You should be encouraging them to use it throughout the year, but use it or lose it. Okay, and so very finally, before we move on to any questions that you might have had, I just wanted to give you an overview of a new COVID-related case that's out of the tribunal system. So this was an employee who claimed unfair dismissal under Section 100 of the Employment Rights Act. That section, says that if an employer dismisses someone for a number of reasons relating to health and safety, it'll automatically be an unfair dismissal. So this chap had less than 2 years service, so he didn't have his right to claim ordinary unfair dismissal. So his argument was that Section 100 kicked in and that they'd failed to adhere to health and safety requirements, and for that reason it was automatically unfair when they dismissed him. And there's no reason to have your 2 years for that. So basically what happened with this guy is that he worked for like a laser cutting place in Leeds, I think it was, and he basically just said, I'm not coming in because I don't feel safe. He didn't say, I don't feel safe because you haven't done a risk assessment. He didn't say, I don't feel safe because you're making me, you know, sit in a car with somebody and you're not providing us with masks, anything like that. He just said, I don't feel safe. And then he just ghosted them. He didn't get in touch with them for weeks. And so they ended up dismissing him. And he said that they had provided an unsafe workplace, and for that reason, it was automatically an unfair dismissal. The tribunal, however, found that he was fairly dismissed. So that means you can sack anybody who won't come in because of COVID then. That's not really the case. Like with anything that comes out of the tribunal system, it's done on a very case-specific basis, and so you need to look at all of the detail of the case. And there were a number of reasons why the judge found that it was a fair dismissal, and some of it was about the positive behaviour of the employer, and some of it was about the behaviour of the employee. So like I said, he didn't say what it was about the workplace that he felt was unsafe. He just said it was unsafe. So in order to implement that sort of area of the Employment Rights Act, you need to show that you are allowing your employer to be able to rectify any mistakes, and it's only if they fail to that kind of kicks in. So because he hadn't specifically said what it was that was so unsafe, the employer couldn't rectify it, so he hadn't fulfilled his obligation as an employee in order to be able to use that. Further to that, and this ties in with what we were saying earlier about health and safety, the employer had got a very robust risk assessment in place, and in actual fact they'd engaged the services of an external provider to come in and do it for them, and they were like super COVID safe, and that really stood them in good stead, because it meant that they could really evidence that they'd been taking it seriously. And I think the judge also found, well, I don't think, I know because he overtly said it, that that one of the reasons that this chap was off was not necessarily because he was scared of COVID in the workplace. He was just generally scared of COVID, and he wanted to stay in. There were a few things he said. He'd got a young child that had got, I want to say, sickle cell anemia or something like that, so quite poorly. So he was worried for his child, bringing it home, and so he was generally concerned about COVID. It wasn't focused on the workplace, and so for that reason, it wasn't work's fault that he was scared. So what are our points to take away from this? So it's certainly capable of being circumstances of serious and imminent danger under section 100, but that's more about your how you deal with it as an employer. And the judge felt in order for this protection to kick in, the concerns an employee has must be specific to the workplace, whereas this chap was just scared of COVID in general. The fact the workplace in question was objectively very safe was extremely relevant to why this claim failed. And similarly, the fact that this employee had not raised specific concerns or stated clearly what the safety concerns were in the workplace was relevant to why his claim failed. So what should you do if someone does raise concerns about health and safety in the workplace? So first of all, you need to sit down with them and do it remotely if they prefer, and explore with them exactly what the nature of those concerns are, get detail on it. Make them be specific, and this will enable you to address them and or explain measures you've taken to address them. Make sure you have evidence of risk assessments, of COVID safe measures, and that these are being clearly communicated and, as I said earlier, are being enforced. And try and understand someone's personal reasons for being concerned. Is it general anxiety? Is it worry about a vulnerable family member or a health condition they may have? And you need to, if you demonstrate that you've explored it thoroughly, that'll help you moving forwards. And consider alternatives. You know, if it is a role that can be done at home, maybe allow them to do it at home, or at least partially at home. Okay, so we're going to move on to questions. Phoebes, I don't know if you've had any. I'll stop sharing so that I can see you.
Thanks, Kat.
Okay.
There haven't actually been any questions, so should we just give people a few minutes to see if they either want to turn their mic on and maybe let us know, or pop them in the chat?
Yeah, given that there's not many people, then it's absolutely fine if people want to just unmute themselves and ask it verbally.
Yeah, there's been a couple of people who have asked for copies of the recording and our home working policy, so that's good.
Mm-hmm.
I think most people are probably getting back to work now. Well, you would hope so.
I think given the change in the guidance, I think that's our experience that you know, it is now more in work than either furloughed or working from home now, isn't it?
Yeah, definitely. The relief.
Okay, so Rob, no questions. Thanks, Rob. Goodbye.
Oh, so there's one just come in. Somebody has informed us that they caught COVID. Could we ask for proof, as it has come to our attention that some use it as an excuse to stay more at home? Yes, so if they can't come to work and they need to self-isolate, then they could either get the self-isolation note from on the NHS website. I think that's still up there. Or if they're actually poorly, then they need to follow your self-certification requirements or obtain a sick note if it's going to last for longer than 7 days. So ideally, yes, they'll give you some proof either through confirmation of their positive test result maybe, or confirmation that they've logged it on the NHS Track and Trace app as well, but it's probably going to fall down to your usual sickness reporting requirements and the proof that they give you under your policy. But yeah, generally, you can ask for proof that positive test.
It's a really tricky one as well, isn't it? Because I think there are quite a lot of people who are swinging the lead, because we know that if you've got COVID, it doesn't necessarily mean that you're ill. You know, you could have it and be fit. It's just that you're not able to come to work. And we completely get there are a number of people who've seen it as a really great opportunity to stay at home.
Yeah.
You know, and there are ways that you can manage that. You can manage it in the same way that you would manage any kind of sickness absence. In reality, a lot of people believe, we see it a lot, don't we, Phoebes, where the employees are saying, well, you're not allowed to take this into account because it was COVID. That's rubbish. You can. It's still absence from the business, regardless of whether it's COVID or flu or appendicitis or whatever it is. It's still a sickness absence. So you could start putting pressure on people by monitoring the sickness absence. Equally, if you've stopped doing as much home working, then you could actually say to them next time they do it, if they do it multiple times, that you're no longer doing home working, so it's going to be considered a period of sickness absence, so they'll be on SSP. Just call their bluff a little bit. That'll be more difficult to do if you've still got home working in the business, because it can be difficult to justify that. But sometimes, you know, a good bluff call is something that we recommend, isn't it, Phoebe?
Yeah, definitely.
Yeah.
And I would just start treating it as a period of, you know, as you would with any other period of sickness.
Yeah.
Or illness.
But interestingly, that one from Yanis, sorry, I hope I've said that correctly, is if they've caught COVID, we're not really seeing multiple occasions of people having caught COVID. Usually if you catch it, you kind of only catch it once. And again, now, and also now that the vaccine, you know, rollout is rattling on at the rate that it is, people are even less likely to get it. So we are going to find that as time goes on, it's going to be less and less of an issue.
Yeah. And another thing to bear in mind as well is if somebody is supposed to be self-isolating and you get some evidence that they are not, or even if you have a cause to believe that it may not be truthful, then I would definitely do an investigation into that. You know, don't just leave it. If you've got cause to believe that they haven't been truthful, then I would definitely investigate that.
Yeah, we've had quite a few, haven't we, where they've said, oh, we need to self-isolate, and then literally have been sat at a bar having a pint of Stella. Like one of them was literally having a pint of Stella at a bar around the corner, and one of the other employees took a picture of them. It was like, bang to rights. So we've had a couple more. So do you want to answer them, Phoebe? Because they're probably bored of my voice now.
So the next one is, as lockdown restrictions ease, do we still need to have a valid reason in order to ask staff to return to work? No. So as you know, we're still waiting for some guidance, aren't we, from the government on the home working position, I believe. But as long as you've got a sound business reason for asking people to come back and you can back that up, then that's okay. And as long as you've got adequate measures in place, then you can ask people to start coming back.
That's the key thing, really, isn't it? It's having a risk assessment and making sure that whatever's in your risk assessment is being done, so that you're not going to give them an opportunity to challenge back on that and put you in a position where you have to allow them to home work again. Make sure that you're tip top on all of that, and they've not really got an issue. You may want to sort of consider it for some people, like I said earlier, if they've got sort of anxieties, mental health issues, or if they've got a disability or they're clinically vulnerable, you might want to still consider it, but for the most part, no, get them back if you want.
Yeah. The next one, what about asking for proof of vaccination? So this one's really tricky. And what I'd say is absolutely ask the question in a return to work meeting. But I think you can't really enforce somebody to give you that information unless you've got a really, really sound business reason to do that. So that will depend very much on the role that they do. So for example, in the care sector, that information is going to be really important, potentially for the type of business, or, you know, for example, if people are maybe going out to see particular clients, those clients are going to want that information, then yeah, in those cases it'd be more reasonable. But if it's just a general office environment, then I would say that you can't force somebody to give you that information. It's going to need to be looked at on a case by case, and I would try to do it more systematically as well. So for example, in a return to work meeting, so if you've got loads of people that have been on furlough and then they're all coming back, I'll be doing a return to work meeting with everybody, and in that I would ask them the question, but if they're not very forthcoming, I wouldn't press the issue, because people have got some very strong beliefs when it comes to vaccinations, and you wouldn't really want to be putting yourself at risk of discrimination by trying to force them to give you that information. And then also, if maybe some people haven't, and then they feel as though they've been subject to a detriment, then that could cause issues as well. So yeah, definitely ask the question, but it very much depends on the business as to whether or not you can try and force them.
Yeah, I think because the government are mandating vaccinations, it's difficult for you as an employer then to sort of go against the government guidance in that respect. And you also need to think about, if you do retain that information, about your data protection and what measures you've got in place regarding your data, because that would be classed as sensitive personal data from a GDPR point of view, because it's medical information. And so you do need to consider that as well. You'll need to tell the staff where you're storing it, how you're storing it, and the retention period for it as well.
And that's where your business reason is going to come in as well, because you need to show that you've got a legitimate reason for collecting that information from people. Yeah. And it may be actually worth updating your privacy notice or data protection policy to that effect as well, if you are planning on collecting that information. So let us know if you need any help with that.
And what you also need to remember is, most people in the smaller businesses, you're all going to know anyway, aren't you? I mean, we're a small business. Jason got his early on because he's really old. And so he was able to get it really early, you know, and so we all knew. He told everybody, and we all talk amongst ourselves, you know, and so even if you're not actively gathering that data, people are likely to just know anyway. So it might be that you get a more kind of, you get that data in a more passive way. And so for that reason, it might be worth not specifically asking the question, retaining the data, because you kind of know anyway.
Yeah, definitely. So there's just another question. Is disciplinary action justified if an employee breaches COVID-19 safety rules? Yes, 100%. But even if it's a very, very basic disciplinary, it seems, you still need to be doing an investigation, as Catherine was talking about earlier, to make sure you've got all of the evidence to back that up. So for example, if another employee sees somebody breaching the rules, then you need to be taking a witness statement from them and anybody else that was maybe there, and making sure that you've got all the evidence to back up your disciplinary process. Yeah, basically, to answer that question, it is justified. You still need to be doing an investigation into it, even if it is quite a minor one.
Yeah, and part of that investigation would also be the reason for it. There is a case, I think it was the first COVID-related case actually that came out of the tribunal, and it was somebody who refused to wear a face mask. And so they dismissed him, and that dismissal was found to be fair, but those reasons were very specific. Like, he wore it everywhere else. There was like this one particular area that he refused to wear it in. This particular area was on a third party's premises, and a third party refused to allow him back on their premises. So the employer had no choice but to dismiss. So it was kind of more those reasons that made it fair rather than just dismissing. So you need to look at every one of them on a case-by-case basis, because if somebody, for instance, has got a disability that means that they can't wear it, then if you dismiss them for that, then that would probably be an unfair dismissal and also a discrimination case as well. So it's not just as simple as, yes, you can dismiss them, or no, you can't. It's about looking at the individual case and the reasons surrounding it.
Yeah, definitely.
And to answer the question, Yanis, yeah, it's the investigation will tell you whether or not it's a conduct or a training issue. Because if part of that investigation is say, oh, I'm really sorry, I thought we were all right not to wear it there, but we had to wear it everywhere else, then that's a training issue. If they're just overtly saying, no, I'm not going to wear it, and there's no justifiable reason not to, then that's a conduct issue. But your investigation will show which one of those it is.
Yeah, 100% agree.
Okay, so have we got any more questions? No?
No, I don't think so. It doesn't look like it.
Yeah, I'd like to put a grievance claim in against Catherine for age discrimination. Please.
Oh, there's just one more question. That's popped in. Let me just read that. As a staffing agency, we place employees with employers on both a permanent and temporary basis. Temp workers are employed by our company, although adhere to the employer's on-site rules and regulations. With regards to COVID, who is responsible for enforcing? Us as the agency or the employer? Both, I would say.
Yeah.
Both. I think the employer initially, while they are on site, the employer. However, if you get reports back that somebody is repeatedly not following rules, I would definitely take them through whatever that process may be. However, it's going to be down to the employer, I think, to, you know, conduct an internal disciplinary process or whatever their process is. But it's going to come down to both of you. And if somebody is repeatedly not following rules, then it may be that you tell them that they will not be, you know, you can't keep them on your books as an agency worker. But there should always be a process followed by the employer.
And remember, the employer, the third party, can say, I'm not having them on site anymore.
Yeah.
If they fail to adhere to their policies and they're within their rights to do that. And then you might not have any alternative work for them.
Yeah, it depends on the internal policies and procedures, as we know, with the agency or with the employer. But it's going to come down to both of you.
Okay, so if there's no more questions, thank you very much, Phoebe, for your answers, and thank you, Jason, as well, for your help. We will sign off and say goodbye and see you next time. And let's see, there might be more cases that have come out of the tribunal that we can talk about, which will be interesting, because more cases that come out, then, you know, the more of a definitive answers we can give to situations, because that's the problem at the moment. There isn't really anything coming through the tribunal because there's such a delay. So it's difficult for us to sort of form opinions on a lot of things. We just need to sort of go with our gut a little bit. So our gut's been correct for the most part, hasn't it? Up to now.
Oh, yeah. Yeah, it's a developing story.
Yes, it is. It's an evolution.
Watch this space.
Okay, so thank you very much for your time, and we hope to see you on the next one. Bye.